Welcome to the Cambridge Financial Podcast with Bert Salazar, CEO at Cambridge Financial Partners, LLC. This podcast is all about tax-preferred retirement planning, economics, financial risk management, and achieving a risk-free and successful financial life. Now, your host, Bert Salazar. Bert Salazar. Bert Salazar.
Good day, everyone. Welcome to another Cambridge podcast. I'm very excited today because we're going to have a really good conversation on wills and trusts and durable powers of attorneys and healthcare proxies and things that are critically important for the majority of you listening to this podcast. Now, because of the fact that I've been in the industry, in the financial services industry for the past 28 years, I have had an opportunity to work with many attorneys and tax attorneys and CPAs and many of my clients in discussing, creating, and designing estate planning tools and techniques to include wills and trusts. Now, I want to use a disclaimer because it's very critical that I do this, is that I am not an attorney. And because of the fact that I am not an attorney, I cannot give anyone on this call or any of my clients any type of legal advice. What I do have, it's a tremendous amount of information and knowledge relating to estate planning and estate planning tools because I've been doing it for many, many years. Now, I have taken many courses, many educational programs relating to business insurance and estate planning and so forth. And by the same token, I have put a tremendous amount of time into the practicing of these features and benefits by working with my clients. Normally, once a year, I conduct an audit on all my clients, and we discuss everything, from investments to rates of returns to tax planning to estate planning to insurance protection, to inflation, to economic issues and concerns that may be happening in the United States at the time. We also obviously discuss retirement. One of the major areas that we specialize in is creating tax-free retirement plans for our clients. So we discuss a lot of those issues and concerns along the way. Now, one of the most critical areas that we pay a tremendous amount of attention to is the area of wills and trust. And normally, a lot of my clients now have wills and trusts in place, but when they first started working with me, I would argue that maybe 25% to 30% of the clients that I first encounter for the first time actually have some kind of a will and trust in place. Now, there is a tremendous amount of misinformation. And also, a lot of clients don't pay a tremendous amount of attention to the importance of having wills and trust in place. And one of the things that I always try to communicate to all my clients is that no one ever dies at the right time. And I have had many clients die over the last 28 years. And what's interesting to note is that many of them have done planning and others have not. And if you have not done any type of planning, or they have not done any type of planning, there's an enormous difference as to the sequencing of how the assets are distributed and so forth. So today we're going to talk a little bit about some topics. Now, I'm not going to give you a very drilled down lecture or podcast on each and every one of these areas, because then it would take us anywhere between 5 to 10 podcasts in order for us to really discuss deep down estate plannings and wills and trust. But what I will give you is enough information for you to pick up some good stuff and also be able to go back to your trusted advisors and or your CPAs, tax attorneys, or estate planning attorneys, and make certain that at least you have a discussion with them in relation to what we're talking about today. Now, most of you and many of my clients think that, trusts are only for the wealthy people, but that's not necessarily the case. A properly constructed trust can serve many purposes, for families and any type of family, especially if you have some modest means or income. Now, a trust is going to help avoid the time-consuming and costly probate process. It allows the family to maintain control of a legacy for the heirs, and it provides for dependent needs, for special needs, and we'll talk a little bit about that, or make substantial contributions to your favorite charity. Now, even if you think about a trust is primarily a legal arrangement in which one person or institution controls property given by another person for the benefit of a third party. So, for instance, when I created my trust with my wife for the benefit of my children, we used a third party to oversee the assets and manage the assets in the trust. Now, that third party could be an individual. That third party, depending on the amount of assets that you may have in your estate, may be a trust company. And obviously for your bigger estates, usually a trust company is going to be used. And please bear in mind that the person giving the property is referred as the grantor. The person controlling the property is the trustee. And the person to whom the property operates is the beneficiary of the trust. Now, there are some trusts that you can name yourself as the grantor, the trustee, and the beneficiary at the same time, but we're not going to go into a lot of details along those lines. Now, although you may be hesitant to give up control of your assets, in some cases, it makes a tremendous amount of sense, and it might be a worthwhile opportunity to choose an independent trustee who would be subject to very strict legal requirements when administering the trust. Remember, the trustee has a tremendous amount of liability because he or she or it must work for the benefit of the trust and the benefit of all the beneficiaries inside the trust. Now, when it comes to trust, I try to keep it simple when I deal with clients, in the sense that think of a trust as a pool of assets, primarily inside a bucket, and that bucket has a number of items, legal documents, and each and every one of those legal documents is going to play a major role and an important part in how that trust is going to be disposed of or dealt with at some point in time in the future. Now, you do have your traditional wills, and traditional wills, are better than not having a will at all. Now, normally when I discuss estate planning with clients, and again, this depends on the amount of assets. If your estate planning is fairly simple, you could probably pay, depending on where you're at in the United States, anywhere between $1,000 and $1,500 to draft a will or a simple trust. If you have assets, more so than the norm, if you're somewhere in the middle class, maybe you'll pay anywhere between $1,500 to $3,000. I know at least in the state of Florida and Coral Gables, you will pay that kind of money to have a trust and a will put together for you and your family. Now, if you have multiple businesses and you have, foreign corporations, and you have a large amount of assets, then you could pay anything between $5,000 and as much as $100,000, depending on circumstances. Now, obviously, if you're very, very wealthy, you may even be paying more than that. So it all depends. But again, when we're having those conversations, many of my clients always think of a WIFM, what's in it for me, and what's, the most that I can get away with, for the cheapest amount of dollars. So they're always asking if a will would suffice. And sometimes it will. But many a times, especially with the type of clients that I deal with, the answer is no. And the reasons is that there are certain features and benefits between wills and testamentary trust, and then your living trust, which is comprised of either a revocable trust or an irrevocable trust. And there are major differences along those lines. So let's go step by step. So for instance, a testamentary trust becomes effective upon the death, and it is usually established by your last will and testament. So a testamentary trust becomes effective at the time of death. Now, it enables you to control the distribution of your estate, and then it works very well from that perspective, but it does not avoid probate. Now, you can change or revoke a testamentary trust during your lifetime. So it does much better than a will from a business perspective. But one of the questions that I get from clients all the time is that, Bert, all of my assets are in trust, so that means that I'm not going to have to pay any estate taxes in the future. And the answer is, well, it depends. Now, if your estate is inside an irrevocable trust, then obviously you may not pay any estate taxes. But if you have the 3 C's, as I call them, the care, custody, and control of your wills and your trust, and you have the ability to make all the decision-making opportunities inside that trust, then it is part of your estate. And depending on the value of your estate, you may have to pay federal estate taxes along those lines. Now, a living trust takes effect during the lifetime. So it is the opposite of a testamentary trust from a business perspective. Now, when you set up a living trust, you pretty much transfer the title of all the assets you want to place into that trust from you as an individual to the trust. Technically, you no longer own the transferred assets. So therefore, once you take a piece of property or an investment and you transfer that to a living trust, you are no longer the owner. The living trust is now the owner of those assets. Now, if you name yourself as a trustee, you obviously still maintain full control of the assets, and you can sell them, you can give them away, as you see fit along those lines. However, the fact that you have control of the assets may negate any estate tax benefits depending on the value of your estate. Now, a living trust can be revocable or irrevocable. Now, a revocable trust can be dissolved or amended at any time while the grantor is still alive. So it's pretty much a living document. You can add to it, you can take some stuff out, you can change it, you can add beneficiaries, you can delete beneficiaries, you can pretty much do anything you want. An irrevocable trust, on the other hand, is generally very difficult to modify or revoke. One of the features that we use with many of our clients is what is known as an ILIT, which is an irrevocable life insurance trust. So for instance, if you happen to die and you have $1 million of life insurance, your beneficiaries will receive that $1 million of death benefit free from federal income taxes. Now, because you own the life insurance yourself at the time of death, then the life insurance proceeds become part of your estate. Now, depending on the size of your estate, you may have to pay estate taxes on that $1 million of death insurance that did not pay federal income taxes to your beneficiaries. So normally, whenever I do business planning and estate planning for clients, and I do have a number of them, where their assets are in excess of the Unified Credit Trust, which we will discuss in a few minutes, then what we try to do is we try to buy life insurance and we place those life insurance contracts in an irrevocable trust, so it would be completely out of the estate. So upon the death of the insured, then the insurance company is going to pay the death claim to that irrevocable trust. and therefore that trust is not going to have to pay federal income taxes or federal estate taxes because the trust actually was the owner and beneficiary of the life insurance contract from the very beginning. Now, obviously, we can get very deep into that subject, but we're not going to do that today in this podcast. So when we look at a simple will, here are some of the features. So does a simple will provide for controlled distribution of assets? The answer is yes. Does a testamentary trust provide for the controlled distribution of assets? And the answer is yes as well. And does a living trust, either revocable or irrevocable, provide for the controlled distribution of assets? The answer is yes as well. Now, when it comes to appointing guardian for minor children, so if you have a family and you have minor children, now a will allow you to appoint a guardian for the benefit of those children. But none of the other, not the testamentary trust or the revocable or irrevocable living trust, will allow you to do that. So you need, if you have small children, then it is critically important that you also have a will in place. Now, all of the documents that I have ever seen have a will in place as well. Now, when it comes to avoiding probate, the will is not going to allow you to avoid probate. A testamentary trust is not going to allow you to avoid probate. A revocable trust will allow you to avoid probate because a revocable trust is an entity all to itself. And the same thing with an irrevocable trust. It will also avoid probate. Now, the big question comes, well, which one of these will actually avoid estate taxes? So what if I have a net worth of $20 million? Right now, the Unified Credit Trust for a married filing jointly is $11,200,000 under the new tax reform. And that was passed by President Trump in December 20th of 2017. But what if my estate is valued at $20 million or $30 million or $100 million or $1 billion? Anything above that unified credit trust will be taxable. Usually it could be as high as 55%. So that could be a tremendous amount of tax liability to an estate of that size. Well, if your assets are either in a will or a testamentary trust or a revocable living trust, then those assets do not, and I repeat, do not avoid estate taxes. Only if your assets are in a irrevocable trust will you be able to avoid not only probate but also estate taxes as well. Now, asset protection is very critical, especially the more assets you have, because you want to make certain we live in a litigious society, so you want to make certain that if you get sued for any reason whatsoever, that your assets are protected. Now, if your assets are in a will, then obviously they're not protected against lawsuits or creditors. Now, if they happen to be in a testamentary trust, they would be protected. Now, there may be some areas where it may not. There's an asterisk that I usually put there. A revocable trust will not protect it because you have the care, custody, and control of the assets as well. But if they happen to be in an irrevocable living trust, then those assets are fully protected from lawsuits and creditors. So it's critical to understand those. Again, whenever you get ready to do some estate planning, and I do work with a number of estate planning attorneys, two specifically that I enjoy, especially, how they tend to explain estate planning issues and concerns, and the fact that they're always looking to simplify matters as opposed to complicate them. But whenever you deal with an estate planning attorney, they're going to send you a questionnaire in which you're going to have to fill out. Not only are you going to have to provide all the assets that you own and the properties and the titling of those properties and so forth, but most important, you're going to have to provide what it is that you want to do with your assets. How do you want to dispose of your assets? So, for instance, when my wife and I set up our wills and trusts many years ago when our kids were small, obviously not only did we have to worry about the appointment of a guardian to take care of the children, because one of the challenges is that, husband and wives always think that, well, honey, if I don't happen to be here tomorrow, that I know you're going to take care of things. And the same way happens if the other party's not here tomorrow, the surviving spouse, will take care of things. But what if none of you are here tomorrow? What if you go out to dinner one night, you and your spouse, and some jerk runs a red light and none of you make it home? Well, if you have small children and you don't have the legal disposition of your assets and you don't have the appointed guardians for your children, everything's going to have to go through probate and the courts. And what the probate judge is going to do is they're going to assign an attorney who's going to be the guardian ad litem, as it is called in legal terms, to take care of the children and to provide for those children. And obviously that's going to take a tremendous amount of money out of the trust for administrative purposes, because basically the state of Florida is saying that if you don't take care of your family, we're going to have to. And the state of Florida has what is called the intestacy laws. So all of us, have a disposition of assets whether we want to or not, but you may not want what the state of Florida gives you. So you want to make certain that you do it properly and that you visit with an attorney and you get legal advice, because the intestacy laws of the state of Florida do not work as well as you would want them to. Now, there are also known three types of trusts, and these are called the special purpose trust. And one is called the incentive trust, and that makes a transfer of assets to heirs, contingent upon their meeting certain goals and expectations, before the assets can be transferred, I want to make certain that my children graduate from college, or they start a family, or they open a business, or something along those lines. Another type of special purpose trust is known as a supplemental or special needs trust. And I have in my portfolio, I believe, 12 to 13 clients that have special needs children. And obviously you need to protect them in many different ways. And one of the many reasons why it's critically important to have a special needs trust is that the needs of those children, even when they're adults, do not go away the day you die, because they're special needs. So therefore, they're going to need care for the rest of their lives, whether you and your spouse is here or not. Now, what's important about a special needs trust is that can help you and your family provide for a disabled child, and may ensure that the child qualifies for, government assistance programs. So the special needs trust has to be drafted in a specific manner. Most important, if you have a special needs child, not only do you have to seek legal counsel and talk to an attorney, but you also want to talk to an attorney that specializes in special needs trust. And then last but not least is what is known as a charitable trust. And this one pretty much enables you to provide, a charitable organization with, regular income for a set, period of time, or a lump sum distribution at the end of that period. Now, obviously I'm preaching to the choir on this one, but there are costs associated with creating and maintaining a trust. So it's very important that you understand, what it is that you're trying to do, and do it in the most economic and possible way necessary. Now, that brings us to the issue of advanced medical and legal directives, and that's something that it is part of all the trust documents that you would see in a traditional trust document for business purposes. Now, one of the things that I try to discuss with my clients on a regular basis is that, it is not pleasant to think about the possibility of being unable to make your own medical or financial decisions. But it happens every single day of the week. But taking the time to express, your wishes in advance can help ensure that your health care and financial affairs are handled as you wish, and that the people that love you feel more confident about any decisions that they may make on your behalf, because you took the time and the effort to make certain that you let them know exactly, what you wanted them to do at a time where you cannot make those decisions for yourself. Now, here again, there are 3 legal documents that you might consider. Now, the first 2 that I'm going to discuss deal with healthcare issues, and in some states may be combined into a single document, called an advanced healthcare or medical directive. Not all the states work the same way. Now, requirements for all these documents vary from state to state, so make certain that you talk to an attorney that specializes in the state that you live in. And that would be very, very important, because they would be familiar with the laws of that particular state. Now, so the first one is what is known as a durable power of attorney for healthcare, or what is better known as a healthcare proxy. Now, a healthcare proxy enables you to appoint a representative to make medical decisions for you in the event that you're unable to make them for yourself. And that's pretty self-explanatory. Now, you can appoint pretty much anyone of legal age, usually 18 years of age or older, and specify how much power you want to give them. The document should be HIPAA compliant, which is the federal rules for health insurance, so your representative can access your private medical information at a time that he or she may need it the very, very most. So again, all of these documents, all of these clauses form part of that entire trust that is put together once you do it for yourself, your business, and your family. Now, the second document that is very important is what is known as a living will. And the living will allows you to outline, which medical procedures you would want to be used to prolong your life. Typically in the event of, terminal illness or injury. It might also include instructions on pain management and other specific wishes that you may want to put together. In some states, a living will may be called by a different name, such a healthcare declaration or instructions for healthcare. So it's got different names, but at the end of the day, a living will allows you to make a decision, what you want done. Some of my clients in their living will, they put a DNR clause in there, a do not resuscitate. So let's say that if you go into cardiac arrest and you have a DNR as part of your living will, then the hospital and the doctors will not try to revive you at that point in time because that's what you wanted to do. If you don't have a will, if you don't have a healthcare proxy, if you don't have a trust, sometimes the courts may have to get involved because no family member can make that decision on your behalf. So it is very, very important that you pay attention because, as I always say, no one ever dies at the right time. And many a times when people die, things are not in order, and that's what trusts do for many of us. It kind of creates an orderly disposition of your assets at the time that you need it the most. And then the last one out of the three is what is known as a durable power of attorney for finances. So you have the durable power of attorney for healthcare, or the healthcare proxy. You have the living will, and then you have the durable power of attorney for finances. And pretty much this one enables you to authorize someone to act on your behalf in financial and legal matters. Now, the person you designate as your agent or person in charge could pay everyday expenses, watch over your investments. They can file taxes. They can, you can actually have this durable power of attorney become effective immediately, or when a triggering event occurs, such as a doctor certifying that you're physically or mentally incapacitated. If you don't have one of those, your family has to go to the court and see if they can seek such an order. You can select the same person to serve as the agent, for the healthcare and financial powers of attorneys, but you aren't required to do so. One area that I caution you to pay attention to is, and this happened in my case, when our children were young, and we put together the appointment of guardian for minor children through our will. One of the things that we did in our trust is we figured that my parents were the very best to take care of our daughters when they were growing up, but my parents were not financial people. So just because someone may be the best person or persons to take care of your children does not necessarily mean that they're the best person or persons to take care of your assets. So you have to be very careful how you do that along those lines. Now, some of the interesting things that has happened now with the new tax laws is that the IRS finally announced what the 2018 estate and gift tax limits are. And as of 2018, the limit for gift and estate tax is $11.2 million per couple. Now, it's official. So for this year, the estate and gift tax exemption is $5.6 million per person, up from $5.49 million in 2017. So that means that an individual can leave $5.6 million to heirs and pay no federal estate or gift tax. By the way, we have had the sunset of federal estate taxes since the very beginning of time, where it has been taken away and then brought back, I think, anywhere from 17 to 18 times. So estate taxes are taxes that you pay when you're passing assets from one generation to the other, and I'll explain that in a minute. But also remember that in this situation, in the new tax law, a married couple will be able to shield north of $11 million, actually $11.2 million from federal estate and gift taxes. And the annual gift exclusion amount is $15,000 for 2018, and it had been $14,000 since 2013. So what does this all mean? It means the following: if you happen to have done very well in your life, and you're married, you and your spouse can shelter $11.2 million from any type of estate tax. So if my wife and I had a net worth of $11.2 million, and net worth is the value of your assets minus all your liabilities. So if the net worth of my family, the Salazar family, was $11.2 million in 2018, and both of us were to die, then no estate taxes are due, and my surviving children would receive the $11.2 million without any estate tax liability. Now, if our estate tax liability, instead of being $11.2 million, was $20 million, just for giving you a number, then anything over $11.2 million would now have to pay an estate tax, especially if my wife and I died at the same time, and the estate taxes have to be paid within 9 months of the filing of the 706, which is the last tax return that is filed when you die. Now, some interesting topics about estate taxes is that at the end of the day, is a tax for being successful in life. And it's sad to see that, because we live in a capitalist society we live in capitalism. We're striving also always to do better and better for ourselves, our businesses, and our families. And then if you happen to have done very, very well, the government is going to come in and try to create an equalizer by taking a large chunk of your money and keep it for themselves. Now, what's interesting about estate taxes, and this is something that is very important to understand, is that if I have a net worth of $11.2 million with my wife, or $20 million, if I'm the person that dies in that car accident and my wife survives, it doesn't matter whether it's 20 million, 50 million, 100 million, $1 billion, everything would transfer over to my wife without any estate taxes at the first death. The problem comes when my wife then dies at some point in time in the future, and now all of those assets are going to go to the next generation. So you have to be very careful how you set those estate planning vehicles and clauses and documents together to make certain that upon the first death, that the assets that should have belonged to you if you were the person that passed away, that $5.6 million gets placed in a separate trust. Now, obviously, your surviving spouse can still have access to it, but that trust is earmarked for your beneficiaries. Now, the other thing that the government gives you is not only the 5.6 of the gift tax, the estate and gift tax exclusion. They also allow you, starting in 2015, to gift $15,000 to anyone that you want. And you can give $15,000 to as many people as you want. Now, if you gift someone $20,000 instead of $15,000, then that difference of $5,000 would reduce your lifetime estate or gift tax. That 5.6 million would reduce it by 5,000. Now, also bear in mind that, let's say that my wife and I have 4 grandchildren. Now I can gift each and every one of those 4 grandchildren $15,000 a year. No gift or estate tax. My wife can also join in that gift, and she can also gift $15,000. So between my wife and I, we can gift $30,000 to each one of our grandchildren for a total of $120,000 annually. And we can do that not only on behalf of our grandchildren if we have the assets, but we can also do it for our children and anyone that we want to help at any point in time in the future. So that's a good thing from that perspective, and it's critical that people understand how those rules of engagement work. So that really works really well as well. Now, let me give you a warning. The 11.2 million number per couple isn't automatic, and that's what I talked about when I say you have to make certain that the 5.6 upon the first death is set into a separate trust. Because remember, under estate tax law, there's something called the unlimited marital deduction, which allows me, if I'm the person that passes away, to leave all or part of my assets to my surviving spouse, free of federal estate tax. Remember, I said that the liability comes after the second death. Now, in order to use your late spouse's unused exemption, a move called portability, you have to be able to elect it on the estate tax return at the time that the first spouse dies. Even when no taxes are due. So it's critically important that when you complete the 706, make certain that you talk to your attorney and or CPA or tax preparer, and make certain that they understand how to complete that form and how to maximize the value of your estate. So along those lines, that professional is going to have an idea as to what the value of your estate is for tax purposes. Now, if you live in one of the 18 states or the District of Columbia, that levy either separate estate and or inheritance taxes, there's even more at stake, because you have to make certain that you do proper planning. And also bear in mind that if you live in one of those states, taxes may be assessed starting at $1. So you may want to go online and Google, where not to die in 2017, and it's going to give you some information along those lines. So obviously we've had changes in the estate taxes. I remember in 2010, the estate taxes went away for 1 year. So for instance, George Steinbrenner from the New York Yankees died at the perfect time, because he died in 2010, but there were no estate taxes. Now, it doesn't mean his family didn't pay anything, because, when the taxes were done away in 2010, obviously some of the assets that the Steinbrenner family owned did not receive the proper step up in basis, which is normally the case. So the liability was there from $1 of the investment. So estate planning is something that is critically important for all of us, regardless of how much assets do you have. Now, obviously, if your assets are not as much as the ones that we've talked about, then you don't need any revocable trust. You need to have a will. You need to have your healthcare proxy. You need to have the durable power of attorney for financial matters. You may want to have a simple trust in place. But at the end of the day, it's very, very important that all of you do your due diligence, that you sit down with your families, because I know it's not a simple conversation. Nobody wants to talk about death, but it's going to happen whether you want to or not. Whether you talk about it or not, death is going to happen. And those that are left behind are the ones that are going to have to deal with, the different challenges and the messes that may have been, left at that point in time. Finally, I can tell you that, the majority of the clients that I deal with do estate planning own a tremendous amount of life insurance. And the reason why life insurance is so important when it comes to estate planning is that it provides life insurance. I tell my clients that is nothing more and nothing less than money in escrow. And escrow closes the day someone dies. See, one of the major problems that farmers have throughout the United States is that they may have a net worth of $40 million, but it's all in land. They have no cash. And if you have to pay your estate tax liability within 9 months of your death, how's the family going to be able to come up with, $3, $4, $5, $10 million in cash in order to pay that estate tax liability? Yes, you can finance it through the IRS, but that's something you don't want to do, because it's going to cost a tremendous amount of money. And even if the farm goes away, or the family goes out of business, the liability is still there and has to be paid. So life insurance is money in escrow. And I don't care what the value of your estate is. You need to make certain that you have proper insurance protection in place, not only to protect your family in case you need to pay estate tax liability. Can you imagine if the majority of your estate is in real estate, and the real estate market drops like in 2008, 2009, and all of a sudden you have to start liquidating assets in order to pay estate tax liability? You may be receiving 10, 20, 30 cents on the dollar. So not only did you lose the opportunity cost of liquidating the assets at the wrong time, but now you have to take that money and pay the estate tax to the government. So again, there are a lot of issues that need to be addressed when it comes to estate planning. Always remember that my goal and our goal at Cambridge is to make certain that we can help you change the way that you see things. Because when you change the way that you see things, the things that you see change. Again, thank you for joining us today, and I look forward to seeing you and speaking to you again next week. Take care and have a great day.